Chapter 2. As to tenants entail. Chapter 3. As to tenants for life. In Shrewsbury v. Shrewsbury, A. Lord Thurlow said, "It has been the wisdom of the administration of justice in this country, in order to introduce some degree of certainty, to lay down this rule, that the act of tenant for life in paying off a charge upon the estate shall, prima facie, be intended to make him a creditor, and the true ground of the inference in favour of tenant for life paying off an encumbrance is the scantiness of his estate, for he cannot be intended prima facie to discharge it, because it would be discharging the estate of another person. A tenant for life, by paying off a charge upon the estate, and in the same transaction merging the security by taking an assignment connecting it with the legal estate of inheritance, prima facie puts an end to the charge. 6. But something more is required to manifest an intention to exonerate the inheritance. The smallest demonstration that he meant to pay off the charge would prevent his representative from coming for the money, but the burden of proof is upon those who allege that in paying off the charge he intended to exonerate the estate. A simple payment of the charge without more by a tenant for life, is sufficient to establish his right to have the charge raised out of the estate. He has no obligation or duty to make a declaration or to do any act demonstrating his intention, but if he pay interest much beyond what the profits of the estate would have discharged, this is a demonstration, prima facie, that though tenant for life, he meant to discharge the estate. A tenant entail without power of alienation, will be considered as a tenant for life, and if no intention to the contrary appear, his personal representative will be a creditor for a charge on the estate paid off by him. And so a tenant of an estate subject to an executory devise over which takes effect, will be considered as a tenant for life, with respect to any charge paid off by him. Although a charge paid off by a tenant for life forms part of his personal estate, yet, if he subsequently purchase or acquire the fee, it would seem that the charge will be merged, as his estate cannot, under any circumstances, be diminished. There can be no reason to keep the charge on foot. A distinction, however, must be taken where the tenant for life is entitled to the fee, subject to intervening estates in remainder, as in Wyndham v. the Earl of Agrament, and Trevor v. Trevor. In such cases the charge will continue as personalty. The principle that merger will not be presumed to the injury of the owner of the estate, applies equally to tenants for life and persons claiming through them as to tenants in fee or tenants entail. Thus, in Faulkner v. Daniel, a tenant for life who had paid off certain mortgages and legacies charged upon the estate of which he was tenant for life, claimed as heir at law of the original settler, to devise the estate and fee, and the effect of holding the charges merged would have been to give to other persons claiming a charge upon the estate a priority over the mortgagees of the tenant for life, and consequently the charges were preserved. And so, in Byam v. Sutton, a testatrix gave to W.S., a married woman, for her separate use, an annuity charged upon real estate, with powers of entry, distress, and sale. S. took her life estate under the same will, subject to the charges upon it, not to her separate use, and survived her husband. The estate became deficient, and the annuities fell into arrear. B. An annuitant, with like powers of distress and sale, filed her bill, claiming priority over S, and it was held upon the like principle that in the absence of any acts showing an intention to merge the two estates, the court would presume an intention to keep the charge on foot. Again, merger will not take place where the rights to the land and to the money are not equal, as where the party is a tenant for life of the land, and absolutely entitled to the money. Thus, in Stern v. Wolff, a testator devised freehold estates to trustees, upon trust, on B.S. coming of age, to raise 2,000 litres, to be then paid to him, and subject to this and other charges, in trust for A. for life, remainder to his first and other sons entail. A. died, without issue, before B. had attained 21 years. It was held that the charge of 2,000 litres had not merged, and that B. was entitled to have it raised. It has been held that charges paid off by a tenant for life and assigned to a trustee for him, will be kept on foot even against his own subsequent encumbrancer. Thus, in Harmon v. Forster, the case was by indenture of the 7th of September, 1812, certain lands were subject to certain outstanding encumbrances, and were settled upon for life, with remainder to his first and other sons in tail. In 1816, A. granted annuities to B. charged upon his life estate. In 1818, A. paid off some of the prior encumbrances, and had them assigned to a trustee for his own benefit, and in 1820, A. and his trustee joined in assigning to C, for valuable consideration, the encumbrances so paid off. It was held that the arrears of the interest of the charges so paid off in 1818 and assigned in 1822, were encumbrances on the life estate prior to the annuitant, and that as against the annuitant the interest payable on the said charges out of the life estate had not been merged by the dealings of the owner of the life estate therewith. The benefit of a charge, however, will be lost if a tenant for life of an estate on which there is a charge to be raised through the means of a term of years, execute a release discharging the trustee from all claims under the settlement in respect of the charge. The terrain, though subsisting, cannot be made use of to raise the charge, and in equity the charge will be merged. This is an instance of a charge, though subsisting at law, being held to be merged in equity. On the other hand, if a charge and the fee of the estate meet in the same persons as trustees, the legal merger would not affect the equitable interest of a tenant for life. The right of the personal representative of a tenant for life to the benefit of a charge which has been paid off will not be affected by the statute of limitations. The act applies only where there is a person by whom the charge is presently payable, or who is capable of paying the principal or interest, or of making an acknowledgment of the rights thereto. Thus, in Borol v. the Earl of Agrament, a tenant for life in 1773, paid off a charge of 25,000, affecting certain settled estates. He died in 1837, having in the meantime taken no steps for keeping the charge alive. It was held by Lord Langdale, M.R., that it still subsisted for the benefit of his personal representatives. On the whole, said his lordship, it appears to me that the statute cannot be applied to a case where there is no assignable person liable to pay the charge, no person who by the delay could be induced to suppose that the charge was abandoned or merged, and where the rent out of which the interest of the charge ought to be paid, is receivable by and belongs to the same person who is entitled to the interest. And in Wynne v. Styan, it was held that where a mortgagee was also tenant for life of the mortgaged estate, time did not begin to run against the mortgage debt until his death. The case of Borol v. the Earl of Agrament also affords authority for the position that a tenant for life paying off charges with the intention of merging them, will not lose the benefit of them if it be shown that he acted under a misapprehension of his rights and liabilities. A tenant for life of an obligator's real estate is not liable to pay interest on a bond debt, and consequently, a payment by him will not be held to have the effect of keeping the debt alive as a charge against the estate. Parole evidence is admissible to prove the object the tenant for life had in view in paying off the charge. The rule established by the cases where tenant in tail in possession pays off a charge upon the estate, is as broad as that laid down with regard to tenants in fee. Merger is presumed unless there is evidence of a contrary intention. It is said that the presumption is that, whether he takes an assignment or not, the debt is gone, as he represents the inheritance, and there is no charge unless there is evidence of an intention that it should continue an encumbrance. The fact of his paying off the charge creates a presumption that his intention was not to keep alive the charge, and in this respect the rule is as broad as that laid down with respect to tenants in fee. In Drinkwater v. Coombe, the rule is thus stated: if a tenant in tail pays off a charge upon his estate, the amount does not become a part of his personal property unless he manifest an intention that it should do so. And if tenant in tail, having the power at his own pleasure to acquire an absolute fee, and to defeat the remainder does not exercise that power, it is reasonable to infer that the remainderman is in a sense the object of his own choice, and this is the reason of the rule for presuming, unless the contrary be manifested, that when the tenant in tail pays off a charge, he means the estate, which in effect he gives to the remainderman, should descend to him free from the charge. The rule, however, is not applicable to the case of a tenant in tail, who is restrained from alienation by Act of Parliament. The case of Shrewsbury v. Shrewsbury was thus: in 1742 the late Earl, with his own money, paid off portions charged by the settlement, and took releases for them. He never took any assignment of the term, nor was there any declaration of trust upon his so paying off the charge. He died in 1789, leaving a will dated in 1749, but without taking any notice of his right to be reimbursed this sum which he had discharged, or doing any other act by which his intention could be known. He was considered as a tenant for life, and therefore his personal representative was a creditor against the estate for the charge so paid off. Again, with respect to paying off a charge, a valid distinction is now established between a tenant in tail in possession and a tenant in tail in remainder expectant upon a preceding estate tail. If a charge is paid off by a tenant in tail in remainder, merger will not be presumed. Thus, in Wigsell v. Wigsell, in which this distinction was first taken, Susanna Wigsell being tenant in tail in remainder of an estate expectant upon the decease of her brother, Thomas Wigsell, and failure of his issue, during the life of Thomas Wigsell paid off an old mortgage due upon the estate, and took an assignment of the mortgage term to herself. Thomas Wigsell afterwards died without issue, and Susanna became tenant in tail in possession, and afterwards died without issue, and without having suffered a recovery. Sir John Leach, M.R., observed, where a tenant in tail in possession pays off a mortgage and declares no intention that the charge shall continue for the benefit of the personal estate, there the charge ceases, because the estate is considered as his own, inasmuch as he may make it his own by suffering a recovery. This principle has no application to a tenant in tail in remainder whose estate may be altogether defeated by the birth of issue of another person, and it must be inferred that such a tenant in tail means to keep the charge alive. When Susanna Wigsell therefore became tenant in tail in possession, this charge subsisted as a part of her personal estate, and not having afterwards declared any intention to the contrary, I am of opinion that it continued part of her personal estate at her death. This distinction was supported by V.C. Wood in Horton v. Smith, E. The court observing that Wigsell v. Wigsell had long been considered as sound law. In both of these cases the estate tail was an accession to the charge, which at the time of the accession formed part of the owner's personal estate, and merger was not presumed. We have seen that the rule of merger does apply where the charge is an accession to the estate by the tenant in tail in possession paying off the charge. There is, however, an intermediate case, where the charge and also the estate tail meet in the party at the same time. Thus, in Grice v. Sure, the party took the charge and also the estate tail at the same time and under the same will, and V.C. Turner observed, the general rule, indeed, is clear, that where a party has an estate in fee or in tail, and at the same time a charge upon the estate, the charge will merge, and he cites the cases of Donesthorpe v. Porter, and Lord Compton v. Oxenden, both of which cases, however, it should be observed, were cases of charges merging in the estate and fee. In Grice v. Sure, however, the charge was held not to have merged on the principle established by Forbes v. Moffat, viz. that merger will not be presumed to the injury of the owner of the estate. In most of the cases where tenant in fee and tenant in tail are said to be on the same footing with respect to the merger of charges, the observation seems to have been made with reference to a tenant in tail in possession paying off a charge, and in this sense no doubt the observations made in Grice v. Shaw are to be understood. Beside the distinctions made by Wigsell v. Wigsell, there remains another case, viz. where a person, without any act on his own part, is entitled to a charge, and he subsequently acquires the estate tail. The case of the Duke of Chandos v. Talbot was to this effect. The party was already entitled to the charge when the estate entail descended on him, and he afterwards died without having done anything to show an intention to keep the charge on foot. The charge was not merged, as the estate which came to the party entitled to the money, was only an estate tail. There is a dictum, however, of Sir W. Grant, in Forbes v. Moffat, which, as explained by V.C. Wood, in Horton v. Smith, is at variance with the case last cited. Sir W. Grant observed, upon looking into all the cases in which charges have been held to merge, I find nothing which shows that it was not perfectly indifferent to the party in whom the interests had united, whether the charge should or should not subsist, and in that case I have already said it sinks. Referring to this, V.C. Wood observes, Sir W. Grant is the speaking, not of a charge which the tenant in tail has created in his own favour by an actual advance of money, but of a charge created by some third person, and as to which the tenant in tail has never, either before or after the estate tail became vested in him in possession, expressed any intention whatever as to whether it should or should not be kept alive. In such a case Sir W. Grant says, it being a matter of perfect indifference to the tenant in tail whether the charge is or is not kept alive in the absence of any indication at any time of his intention on the subject, the court will assume that the charge was meant to sink for the benefit of the estate. The following is a summary of the distinctions which are submitted as warranted by the cases. 1. Where a tenant in tail in possession of an estate pays off a charge upon that estate, merger is presumed, unless there be evidence to the contrary. 2. Where a person becomes entitled to an estate tail, and also to a charge upon the same estate, at same time and under the same instrument, merger will be presumed in like manner, unless it would be prejudicial to him. 3. Where the estate tail is an accession to the charge, or in other words, when the party who acquires the estate tail is already entitled to the charge, the merger will not be presumed, but there must be evidence to prove the intention. In Trevor v. Trevor, Sir John Leach, v.C., held that a charge which had been paid off by a tenant for life was not merged by the accession of the fee. Whether the charge should be held to be subsisting in such a case where it can be of no importance to the owner of the estate and the charge, whether the latter merge or not, and his estate cannot be diminished, it certainly is reasonable to hold the charge subsisting where the estate tail is acquired subsequent to the charge, as it might be of the greatest importance to the tenant in tail to retain the charge as part of his personal estate, and he might die before the estate tail was barred, or before he had the opportunity of expressing any intention relating to it. A charge paid off by a tenant in tail under a misapprehension of his rights, will not occasion a merger of the charge. Thus, in the Earl of Buckinghamshire v. Hobart, a tenant in tail believing himself to be seized in fee, subject to a term for securing a charge, made a mortgage as of the fee, and out of the proceeds paid off the charge, leaving the term outstanding. It was held that, though there was an intention to destroy the charge, yet, as the whole estate could not, under the circumstances, be enjoyed according to the whole intention, the term, never having been assigned, should be considered as subsisting to secure the amount of the original charge. And in Kirkland v. Smith, a tenant in tail paid off an encumbrance on the estate, but took no assignment of the term to himself, and, apprehending himself to be owner and to have power to dispose of the estate and fee, he settled it upon his family. The persons entitled under the remainder subsequent to the estate tail, which had not been barred, claimed the estates, and it was held that the charge was not merged, and that they must make satisfaction to the personal estate of the tenant in tail. If tenant for life and tenant in tail in remainder join in a resettlement of the family estates, and family mortgages are paid off by the tenant in tail, and no assignment of them made to trustees for his benefit, they will be merged for the benefit of all the persons who are to take the estates in succession. If land tax be redeemed by the guardians of an infant tenant in tail, it will be held as a charge upon the estate in the possession of the remainderman, and in a suit instituted for that purpose the court will direct the persons having the legal estate to make the charge binding on the inheritance forever. And where a tenant in tail, who was also owner of the land tax, which had been redeemed, suffered a recovery and settled the estate, the charge was held subsisting. A separate account had been kept of the rents of the estate and the charge, and this afforded a presumption against the general words which the settlement contained, that the charge was intended to be kept on foot. A transfer of a charge to himself by a person who is not tenant in tail in possession at the time of the transfer, will not be considered as evidence of an intention to merge the charge. Although merger will be presumed in the absence of any evidence of an intention to keep the charge on foot, yet, if the acts of the tenant in tail afford evidence of such intention, the charge will be preserved as part of his personal estate, and parole evidence is admissible.